intended regulatory action to make substantive changes to the biosolids reg back in 2008. It's actually the Virginia Pollution Abatement Permit Regulation, but for purposes of brevity, we refer to it as the biosolids reg. The amendments, the process was long, both in terms of the amount of involvement we had with the Regulatory Advisory Panel and executive review. So it wasn't until September 1st, 2013 that the amendments to the biosolids reg actually took effect. After that, there was an administrative appeal filed by the Potomac and Shenandoah Riverkeeper, alleging that the regulations were unlawful because they did not ensure that human health and the environment were protected. I just wanted to let you know that on December 17, 2016, the Richmond Circuit Court found that the board had met its statutory duty to promulgate biosolids regulations that, one, ensure land application is performed in a manner that will protect public health and the environment, and two, prevent the escape, flow, or discharge of sewage sludge into state waters in a manner that would cause pollution, and three, there was substantial evidence in the record to support the board's approval of the regulations. Some of you may not even have known that challenge was out there, but it has been resolved in favor of our regulation, and there was no appeal filed of the circuit court's decision. So I just wanted to bring you up to date on that, and I'll turn the podium over to Neil.
Thank you.
Thank you, Melanie. Good morning, Mr. Chairman, ladies and gentlemen of the board. I have for your consideration this morning a permit modification request from Synagro Central LLC to add land to their BPA permit, BPA 01576, to add additional land application sites. As I walk through the presentation this morning, I'll give you a little bit of background information on the permit action, summarize our public participation for the permit action, and offer a summary of our public comments that were received, as well as the agency's initial response to those comments. And following consideration, questions from the board will offer staff recommendation. So this permit modification application was received in 2014. It was deemed complete in June of 2015. The existing BPA permit that Synagro holds for Nelson County authorizes land application on 34 fields at 4 different sites, totaling 688.3 acres. They submitted a permit application to add 69 fields located at 5 separate sites that total 1,581.4 acres. Also, in this permit modification, DEQ is proposing to incorporate amendments to the regulations pertaining to biosolids. As Melanie mentioned, the amendments to the regulations that we promulgated that became effective in 2013 changed some of the rules and permits. And so the original BPA permit that was issued to Synagro was issued in 2011. So with this modification to add land, we're also adding in those additional regulatory requirements from 2013. So on June 8th of 2016, DEQ held a public informational meeting in Nelson County. There were approximately 47 citizens that attended. Public interest was significant and spirited. And on August 30th of 2016, DEQ completed a draft permit. Because of the significant public interest that was expressed at the public meeting, Synagro requested that we go ahead and move to public notice of not only the draft permit, but also notice of a public hearing. So we did that on November 3rd of 2016, noticed public comment period on the draft permit, as well as announcing a public hearing to be held. That public hearing was held on December 8th of 2016. There were 22 citizens that attended. One citizen spoke in favor. There were 13 that spoke in opposition. Mr. Dunn, our chairman, served as the hearing officer. And on January 6th of 2017, the public hearing comment period ended. We received 53 written comments. 2 were in favor, 51 were opposed to the permit. 43 of those comments were essentially the same letter. Also, it's of note that there were some changes to the draft permit that were requested by the permit applicant Synagro following public notice of the draft permit. There were some fields and some sites that were removed from the permit application based on requests from landowners. So what I'd like to do now is walk through the summary of comments and the agency's response. And I will say that a lot of these concerns you will have heard before in previous biosolids permit actions, but there were some unique concerns expressed in Nelson County from the citizens, and I'll note those. So the first concern was one we've heard a lot, which is related to biosolids composition and protection of human health and the environment. Risk from nanomaterials, emerging contaminants, those that aren't regulated in the EPA regulation, the constituents in biosolids, the effects of those chemicals and constituents, and again, those concerns over the unknown. The effects on breathing and spread of disease, the unique topography and whether or not that would have any effect on transmission of disease, concerns about food companies not accepting products from land that is using biosolids. Again, there's concerns about the food chain. Concerns that because there were restrictions on certain crops and land application, that somehow that implied that biosolids weren't safe at all. Health effects after land application in general, and generally that the permit was not protective of the health of citizens. So the agency's response here, the State Water Control Law requires permits for the land application of biosolids. And this permit was written in accordance with the law and regulation that's designed to ensure protection of human health and the environment. Regarding those additional constituents, you've heard me say this before, the Clean Water Act requires EPA to review the existing federal regulations at least every 2 years, and at this time EPA's review has not identified any additional pollutants for regulation. Also, the Virginia Department of Health assisted with DEQ's development of the revisions to the EPA regulations and conducted a follow-up review of those regulations in 2014. And consistent with their earlier reviews, they found that recent literature did not find any contributory associations between biosolids land application and adverse health effects. So essentially, until there's new relevant research to conclude otherwise, DEQ is confident that the EPA regulations and permits are protective of human health and the environment. Concerns regarding sampling and testing, that there's not enough testing. Concerns over the methodology, testing again for those constituents that aren't regulated in the permit. Concern that there are other heavy metals other than the 9 that are regulated in the permit. Some concern about an EPA study that speaks to protection of water resources regarding chemicals that enter the wastewater treatment system. Testing of the biosolids before land application, disclosure of those results. Again, request that every load of biosolids be tested, and along those same lines, increased frequency of the testing after land application. So everything that we monitor and include in the permit for testing the constituents in biosolids and their frequency is consistent with the federal regulation. And that frequency is dependent upon the amount of biosolids that's land applied from a particular source. The more biosolids that a wastewater treatment plant land applies, the more frequently that testing must be done. The contamination of industrial sources entering a wastewater treatment plant is controlled through treatment programs. Those, primarily to protect the biological populations in the activated sludge treatment plant and limit the harmful levels of pollutants in the solids. And again, the concerns over monitoring by the permit holder rather than DEQ, the self-monitoring is a primary component of the regulations that we use to implement the Clean Water Act requirements consistently, and it's used extensively throughout a number of water permits. We received comments concerning livestock, wildlife, and domestic animals, concerns about disease in deer populations, concerns about human consumption of livestock, and contaminants being passed up through the food chain, concerns about fish in local waterways, and whether or not the food that was produced on biosolids applied fields was disclosed on those food products, and a request that no food production should be allowed on sludge feeds. So the regulations do require restrictions of livestock grazing for 30 days after land application. The expert panel, the biosolids expert panel that was convened at the direction of the General Assembly in 2007 and 2008 did consider the issue of livestock and wildlife, but it was determined that that limited exposure from wildlife poses no greater risk than normal ag activity. Also, the federal risk assessment that was used to prepare the 503 regulations did not find that wildlife posed a significant risk of pathogen transmission. And as far as the protection of state waters and fish in those state waters, the draft permit does require best management practices that are designed to protect state waters. There were concerns about landowner consent. State water control law requires that the land applier receive consent of the landowner before biosolids are applied, and questioned as to whether or not the landowners were fully aware regarding the sources, regarding their liability, what financial risk was posed to the farmers if sued by the neighbors, and a reference to a scenario in Pennsylvania where farmers are liable for decreased property value, and that farmers should be relieved of any liability for accepting biosolids. So permit applications do include the landowner's written consent, and also attest that they received a copy of a DEQ fact sheet that explains the process of testing and biosolids information, where it comes from, the treatment, the required testing, and the research that has been done and has not been done. Also, as a requirement of state water control law, Synagro does maintain an environmental liability policy to pay claims for cleanup, injury, and damage resulting from transfer, storage, and land application. So under the context of the EPA permit regulation and state water control law, it is the land applier that assumes liability for any damage and injury. There were concerns about the accumulation of heavy metals, whether or not the heavy metals that were continually applied at the low levels that are present in the biosolids could be biosolids land application sites equivalent to a hazardous waste dump. Whether or not DEQ had calculated the cumulative annual pollutant loading rate for the sites that had been applied under the previous Virginia Department of Health regulations as well as EPA plans. So with respect to heavy metals, we have the 9 that are covered in the federal regulation. And EPA addressed the concerns about accumulation in the development of the federal reg upon which the EPA reg heavy metal limitations are based, and found that accumulation at the levels, at the concentrations present in the limits prescribed in the EPA regulation would not cause problems. And the idea that how the accumulation over a period of time, even at those low levels, would not cause a problem is really based on the fact that we don't have heavy metals that are disappearing. There's still conservation of mass, but that the organic matter that's in the biosolids that are being added simultaneously to the heavy metals acts as a sink for those heavy metals. So they're not mobile, they're not moving anywhere, they're not acting as something that would be an accumulation problem with respect to the crops that are present. As far as whether or not DEQ has calculated those cumulative rates, no, we have not, because the annual pollutant loading rate for Class B is the regulatory requirement is not applicable where the concentrations of those metals are below specified limits. It's only when the concentrations of metals in biosolids reach a certain level where the calculation of the cumulative loading is required. And so that accumulation issue is not something that the regulations see as an issue when they're below those levels. Concerns about odor, including, in this case, a request for air testing at biosolids land application sites. So I should mention that the regulations do not prohibit odors. The regulation does require mitigation of odors by the biosolids generated from the land appliers. One of the requirements in the federal reg and mirrored in the BPA regulation are the vector attraction reduction requirements that require certain treatment that does in fact reduce odor. The draft permit requires an odor control plan that includes methods to minimize odor during generation, before it leaves the plant, before it's land applied, and the use of incorporation if it is land applied. And those odor control plans are an enforceable part of the permit should malodor become an issue. The regulatory advisory panel that was convened in 2007 for the promulgation of the revised BPA regulations did consider whether odor testing, odor measurement was something that would be appropriate, but that methodology still has a certain subjective component to it. And so that was not included. As far as air testing, that methodology and equipment has really not been standardized as a commercially available product that you could use consistently and suitable for regulatory measurements. So there really isn't a consistent way to require air testing on these open land application sites. General concerns that the laws, regulations, and permits are not sufficient, and that the regulation should be reevaluated, that the permit should be denied until the Joint Legislative Audit and Review Commission study that was commissioned by the 2016 General Assembly has been completed, that the 100-foot river setback is not sufficient, and that it should consider elevation of the upslope land application sites. Request to increase setbacks for wells and surface waters, increase signage, and requests for biosolids-free zones in a county, as well as concerns that the 25-year, 24-hour storm terminology is outdated. So DEQ has processed this permit modification in accordance with the current law and regulations. The Health Department's latest review in 2014 had affirmed that the regulations remain protective of human health and the environment. The JLARC study that's currently underway and will conclude at the end of this year will analyze the current scientific literature again on health effects of biosolids. It will evaluate the feasibility of requiring Class A treatment, as well as conduct some other analyses. And that legislation that set that study in motion did not prescribe any delays on DEQ's part for issuing permits. So there was no directive given to DEQ or authority to delay permit issuance until that was complete. What we do have in the permit is a reopener clause that allows us to reopen the permit should any of the findings in JLARC's study indicate that changes should be made to state water control law or the BPA regulations. If any of those changes would necessitate changes to the permit, DEQ can reopen that permit and make those changes. There were concerns about the use of Class B biosolids and Class A biosolids. Some of the same concerns that initiated the JLARC study. Suggestions require that Class A material only be applied, as it is treated for pathogens more completely. That Class B biosolids require more stringent oversight. That Class B should not be used in urban areas, but it's allowed in rural areas, and that was showing a disregard for rural citizens. So the characterization of Class A or B refers to the level of pathogen reduction, the pathogen treatment that occurs in the biosolids during treatment. The Class A material does contain fewer pathogens than Class B. And so because of that, the federal and state regulations require site restrictions, which include setbacks and other site restrictions for land application of the Class B materials that have a higher level of pathogens. And the public exposure and access to those sites determine what public access restrictions and crop harvest restrictions occur. JLARC, that study will consider the feasibility of upgrading facilities to generate Class A. And also, I just note that Class B could in fact be land applied in an urban area, just as it is in rural areas, but those access restrictions are required for a longer period of time. So there's not a general prohibition for rural areas that's the only place that Class B would be applied. Concerns again regarding property values, truck traffic, quality of life in general. Concerns that the agritourism that is occurring in Nelson County could be affected. The fruit and vegetable production would be a problem. That there would be a decrease in tourism due to odors, and that there would be contamination of the rivers that would affect the fishing as well as water recreation. So again, the permit was prepared in accordance with the law and reg that is designed to protect the quality of state waters and as well as reduce that potential for odor impacts. The biosolids expert panel considered these issues of effects on the community due to odor and included that requirement for the odor control plans. And as far as the considerations for truck traffic, the BPA permit requires that transport routes comply with all the DEQ requirements and standards. There were requests for baseline testing of groundwater wells before land application and quarterly testing after land application occurs. The permit does not require that baseline testing and post-application testing because we rely upon the best management practices that are included in the permit to make sure that those aren't concerns. And those best management practices, the development of those and the criteria for those based on non-point source pollution research that included that pre and post land application monitoring of soils, of surface water runoff, as well as groundwater. And so that's, as long as those criteria are followed, we do not require that testing, ongoing testing of the permits. If there was non-compliance suspected due to our inspection program, DEQ would consider post-application or some additional monitoring to determine if there were any possible environmental impacts from that non-compliance. And I'll also just note that biosolids land application is consistent with the U.S. Department of Agriculture Natural Resources Conservation Service soil health goals in that it adds organic matter. And that's been seen as a quality improvement aspect that actually does increase water holding capacity of soils, increases infiltration and reduces runoff, so that these soils would not be as susceptible to delivering contaminants to surface waters. There were concerns about the permit applicant's compliance history, whether or not the permit applicant's compliance history should be a concern, responsibility for any damages. So I should note here that there was an error in the draft response to comments that was included in your board books that indicated that Synagro was currently operating under an administratively continued Department of Health permit. That was incorrect. They actually are operating now under a VPA permit that was issued in 2011. Just to note that they do not have any current compliance issues in that county, nor are we in any other significant compliance issues anywhere else in the state. So, and pursuant to Virginia Code, holding a permit does not constitute defense in any civil action involving private rights of adjacent or nearby property. The code and the regulations do require Synagro to maintain a environmental liability policy, as I mentioned before. So they are the responsible party in the event of personal injury and personal damage. Questions about DEQ inspections? Whether or not DEQ was staffed to adequately inspect application sites. And so the state water control law requires that DEQ conduct random unannounced inspections during land application with enough frequency to determine compliance. DEQ collects fees according to state water control law from the generators of biosolids that are used to fund our inspection staff that monitor land application of biosolids. And that fee is based on the total amount of dry tons that biosolids in the land apply in Virginia. So with more Class A biosolids being produced, DEQ has focused its inspection efforts more so on the Class B land application. And just to note that even with that reduction in the income, because more Class A material is being produced, we still inspect biosolids land application sites at a higher frequency than any other entity that's included in other permitted activities. Concerns about setbacks from surface waters. And this was a unique question, concerns for swimmers and kayakers, and why waters are not considered publicly accessible sites for purposes of establishing the minimum setbacks. So the permit prohibits point source discharges except during the 25-year, 24-hour storm to protect discharges to surface waters. And the VPA reg and the permit, or draft permit, as I explained, requires those best management practices that protect surface waters and keep the biosolids from reaching those areas where folks would be recreating. And when we developed those areas and places where the setback should be extended for health reasons, we consulted with the Virginia Department of Health in that consideration and in the development of those extended setback guidelines, including that 200-foot setback from a publicly accessible property line. And so when we consider on land a setback from a publicly accessible property line, that 200-foot setback, we exclude a public road because we're expecting that that's acting as a travel way and folks are moving through intermittently. And in this sense, where we're talking about a kayaker, the river is essentially acting as a throughway, a travel lane, similar to a road. And so we're expecting that exposure, unlike a terrestrial scenario, is going to be very much intermittent, as opposed to a pedestrian site where someone might be exposed at a publicly accessible property line. So no, the 200-foot setback from a publicly accessible property is not included. But I would say that if we had a recreation area, a swimming area that was identified, a public park that was identified, that was on state waters, publicly accessible waters, that would in fact institute that 200-foot publicly accessible property line setback. A concern that the neighbors were not being treated fairly with respect to the farmers. and citing the 14th Amendment that everyone's entitled to equal protection of the law. And again, this draft permit was developed in accordance with the DPA regulations promulgated under authority granted in state water control law and in accordance with the Greater Administrative Process Act. And finally, we did have some commenters that supported issuance of the permit and biosolids use. And those support comments included the fact that biosolids should be reused as a renewable resource. They improve soil health, growth and productivity is a byproduct of biosolids use, that there's economic benefit to farmers as well as municipalities for biosolids utilization. That there's increased soil fertility as evidenced by control of some undesirable species and to allow more palatable forages to thrive for livestock. A number of farmers commented that they had not had any ill health effects from biosolids land application, and that the use of biosolids allows farming to continue versus selling off that land for development. So, and DEQ acknowledges the support of those citizens for the permit. So at this point, I'll just ask if the board has any questions, or if, Mr. Dunn, if you have anything to add regarding your presence at this hearing.
I guess my comments would be, I think you pretty well covered the topics that I heard during the public hearing. There were several
for you and one for each of them.
comments about the unknown, what if. I think we got a JLOC study that will look at that, and I am glad that the permit has a reopener clause, which will help deal with any issues that we find out about that we don't currently know about. Turn to the board, Berta.
Thank you. Regarding the 2013 regulations, were those in effect September 1st, or were they staying pending the litigation? They were in effect, so anything approved since then has been using those?
Yeah.
Okay. The other question I had, did you have any site-specific health issues that you had to deal with, or were there any people that came forward with site-specific?
Sarah, did we have any extended? Yeah, no, we did not have any extended setback requests.
Do you know if there is any local biosolids regulation in Nelson County?
I do know that Nelson County has a local monitor.
Okay, they do. And do they have zoning? Do they have a zoning code?
I'm not aware.
I had a quick question about the permit. Well, it's sort of just the definitions. What is a site versus a field? Sometimes there's sites, sometimes there's field.
Those terms are defined in the DPA regulation. A site can contain multiple fields. So a site, we added that definition to address the concept of farm that was introduced in state water control law, and when a farm is added to a permit requiring additional adjacent land under it. So a site is that contiguous area that is land applied on. So you might have one site that has 10 or more, or any number of fields. A site might be one field, or a site might be 25 fields.
Really? Okay. I'm not used to that, because I mean, the Eastern Shore is like, 600 acre. It is one.
Yeah.
Yeah.
Yes.
Let's see. The issue of the nanoparticles. Do you know the status of that as far as the federal regulation? Because isn't there supposed to be a limit on the input of those into the sewage treatment plant at this point, or coming up soon, I guess?
I know that there have been some changes in requirements for certain products that
Yeah.
contain them. I'm not aware of any changes in regulation that affect the solids at wastewater treatment plants specifically as of this point.
So the idea is that when they're not in the products anymore, they won't be in the waste.
Exactly, which we've always considered to be the best solution as opposed to trying to figure out how we should manage them in the solids, keep them out of the waste stream in the first place.
Okay. And then, as far as Nelson County and the general ag community there, do they have a lot of truck crops? Is there tomato or cucumber or anything like that?
I'm not sure of the diversity of cropping in Nelson County. I will tell you that none of the sites proposed for biosolids land application are include anything other than row crop, ag, or hay and pasture. And so while it is legal to apply biosolids on some of those crops with the harvest restrictions, so far in Virginia, we've not had any land applier that has proposed to do that. The land application is solely on row crop, grain crops, hay and pasture. And as far as the protection of those adjacent crops, certainly the BMPs come into play.
That's what I was thinking about, because there was a case on Eastern Shore actually where they had a big E. coli outbreak with tomatoes, and it turned out that gulls were feeding at the landfill and picking up the E. coli and then, dropping it on the tomatoes. And they had to change some harvest practices because there really wasn't anything they could do to convince the gulls, not to do the gull thing. Anyhow, all right, that's thank you.
Any other questions on the board? Okay, thank you.
Ready for the staff recommendation?
Yes. Wait a minute.
Oh, okay.
Got a public hearing.
Public people. People first. First is representative from Synagro.